very much. Really appreciate that. Let me next turn to Robert Becker, representative of the DC Open Government Coalition. Good morning, Mr. Becker.
Good morning, Chairman Allen, and thank you on behalf of the coalition for allowing us to testify here today. As I noted, I am a director of the coalition, and in my day job for the past 30 years, I have been a criminal defense lawyer representing indigent defendants in the DC and federal courts. But as we did in 2017, last time the council considered bills like this, the coalition would like to go on record supporting the underlying goal of ensuring that DC residents are able to move on from their past contacts with the criminal justice system without having public or private entities deny them access to basic necessities of life. But as in 2017, we oppose these bills. If this council is serious about making the goal a reality, it should take serious action. You should enact laws prohibiting government and private entities from denying housing, credit, jobs, and other life necessities because of a person's past criminal contact. And you should enforce that prohibition with penalties for misuse of criminal case information. In the internet age, the bills before you today do little more than create the illusion of protection against discrimination arising from such misuse. In creating that illusion comes with a very steep cost to all DC residents. It deprives us of the ability to evaluate the performance of actors who wield tremendous power over those ensnared in the criminal justice system. And a system that evades public scrutiny is ripe for abuse, and these bills will significantly aid and abet evasion. They will seriously curtail examination of the criminal justice system by the public, news media, community groups, and public interest organizations. In addition, these amendments would hinder efforts by DC residents charged in the future to defend themselves against police and prosecutorial overreach. Some witnesses today have given a nod to the right of the public and news media to access criminal case records, but their solutions to make anonymized or de-identified data public would be grossly inadequate, as our written testimony demonstrates. The coalition has provided examples of how news organizations, the ACLU, Maryland Public Defender, and the Justice Department have used pleadings, orders, and other case documents that would be sealed by these bills. Redacting names from such documents so they can be released would be extremely expensive and impractical. Unfortunately, it appears that in this council period, these bills are just the first salvo in a campaign to cut off from public scrutiny a vast amount of information about DC's criminal justice system. Our concern is the Restore Act Councilmember Henderson introduced April 1st, but we will leave our comments about that bill for a future hearing. Bill 24-63's major proposal and its first major flaw is that it would automatically seal all court and related police records 90 days after the case ends in many, if not most, misdemeanors and many felony cases that do not result in convictions. Whether the government dropped the charges, the defendant was acquitted after a lengthy trial, or the DC Court of Appeals vacated a guilty verdict due to a procedural trial error, all records would be hidden from public view unless prosecutors object. The second major flaw is that it would seal misdemeanor and felony convictions purportedly in the interests of justice. But the standard for assessing what is in the interest of justice does not even recognize, much less take into account, the substantial public interest in access to criminal cases. And for just a moment, I would like to exit my role as transparency advocate and speak to you as a criminal defense lawyer, who, as I said, has done for 30 years represented defendants in these courts, up to the Supreme Court. In furthering my client's interests, particularly in response to prosecutors' harsh sentencing requests, I have relied on pleadings and orders in past cases, sometimes going back as much as 10 or 15 years. I could tell you without equivocation that if enacted, These bills will deprive future criminal defendants and their lawyers of an invaluable trove of information to defend against police and prosecutorial overreach in the future. We encourage all involved to engage in an open process to determine how we can help DC residents improve their lives without impairing the public's constitutional interest in access and without impairing the ability of DC residents to defend themselves. We believe a balance is possible and appreciate the opportunity to work together to identify and achieve that balance. But the bills before you today are not the solution, and the Restore Act, which would seal or expunge more criminal cases more quickly with fewer safeguards for public access, certainly is not the solution. Thank you.
Thank you very much.